My lord, has it para 9? It will be seen from this section that the Act.
What is it? And then say, even if you take it as a.
May I take your lordships through it? Para 9.
Yes.
It will be seen from this section that the Act does not apply to the state of Punjab. However, by notification in this official gazette, a state government can extend the whole or any part of the Act to its territories. Similarly, a state government has been given power to exempt by notification, either retrospectively or prospectively, any part of the territories administered by such state government from all or any of the following provisions of the Act, namely Section 54, para so and so, 59, 117, and 123.
Ms. Kaju,
My lord.
we read para 12, right?
My lord.
Come to para 11.
My lord.
See, your clients,
My lord.
they claim to be the owners in possession of the suit property.
Yes, my lord.
Your first plea was that we have become owners by way of adverse possession.
My lord. My lord. My lord, the WS I would
You
submit.
will have to accept this.
My lord,
Just a minute.
please,
Trying to understand.
please.
Now, at the same time,
My lord.
Paras Ram, he said that he had entered into possession of the suit property with the permission of Zile Singh.
In exchange, my lord. My lord.
Then the High Court says mere long possession does not graduate into ownership being adverse possession.
Yes, my lord.
Until and unless the party claiming to be in adverse possession is able to show the date on which his possession, we are not concerned.
My lord.
Paras Ram admitted to be in permissive possession, and there is no date on which the possession became hostile. Now, once you bring the case of exchange,
My lord.
right, your plea of adverse possession fails into insignificance. Wait a minute.
I'll go with your lordship.
Perhaps you may have some case. So forget about that adverse possession.
Very well.
Now come to para 12.
My lord.
You take us to your written statement.
Yes.
And point out where have you said about this oral exchange?
Yes, my lord. I'll just take your lordships there. My lord may come to an extra P2. Page? That's at page 112. Where's that?
P2.
Yes, my lord. P2 is the WS.
Which is the relevant paragraph?
Now, my lord, I'll just show you. As far as the plea of adverse possession is concerned, we say that we have become owners of the house in question by way of adverse possession also. And then my lord may come to page 114. Where I set out the. Now, my lord, in 114, I show that where my possession begins, and then 115, my lord may see.
No, take us to.
Yes, 115. In fact, the fourth line from the top. Fourth line from the top. Shall I continue?
Your matter is safe so far. Something.
So far may be the operative words. In fact, defendant number 1, fourth line from the top, gave commercial plot for the purpose of constructing 2 proposed shops in the area of so and so to the plaintiff Zile Singh, read sale deed number so and so, and in fact.
Sale deed?
Yes.
Who executed the sale deed?
Zile Singh, my lord.
In your favor?
No, my lord. I'm sorry. It is executed by us in favor of Zile Singh.
Correct.
Yes, we transfer that, my lord, and our case is by so and so. Now, since this said, and no consideration was paid to the defendant number 1 by the plaintiff. Since the said plot of so and so, commercial plot was not in the name of defendant number 2. Hence, civil court collusive decree could not be executed, passed for formalities purpose. The sale deed was executed.
Which they executed.
the exchange.
m-
Sale deed,
My lord,
sale deed must reflect the exchange.
my lord,
Or we start you assuming
Yes.
this law of registration,
yes,
Transfer of Property Act, 118, etc., inapplicability is correct.
yes.
It doesn't foreclose having a document for
Now,
exchange.
may I submit? Now, your lordships may turn to page 51 of my compilation. This is the very question which arose before your lordships. Notice was issued, but the question was left unanswered. May I
Just
submit?
saying, if your case is
My lord.
exchange was in consideration
My lord,
of the sale,
my lord,
the deed must say that.
my lord. So may I then pause it? And that is the
One more question.
please,
Pauses the case.
In the sale deed,
my lord,
which y'all executed in favor of Zilis,
my lord.
there is no sale consideration.
My lord, that's the case. Otherwise, I can bring that document before your lordship. But if I can just show your lordships page 51.
Brother pointed
Yes.
out to you.
Yes, that's the case also, my lord, in the WS. May I just point out page 51 from the compilation for the sake of completeness to your lordships?
Digital oral exchange.
My lord, so in fact, in this case, then a question will arise
You are
that,
saying that the oral exchange is
Yes.
pegged as consideration, a
yes,
sale deed.
yes,
The normal question will be,
Yes.
sale deed reflect that?
yes,
Or do you have any other document?
Indeed.
Leave by the second part. It must reflect.
indeed. But your lordships, that is where I would humbly submit that there's a question which arises for your lordships to answer. And the reason that this is not done by the High Court, my lord, in second appeal is that section 41 of the Punjab Courts Act states that no question of law is required to be.
That is settled by constitutional bench.
Yes, I bow down.
Better.
So therefore, my lords may just turn to page 51 of the compilation, if I may read.
Finding of fact,
My lord,
three courts.
my lord,
None of the attesting witnesses was examined by you
my lord,
to prove the sale deed executed in favor of the plaintiff Zilis by you without any consideration. That's it. Once the parties appeared before sub-registrar for registration,
my lord.
what stopped them from executing an
Yes, my lord, but I would submit, this, my lord, where the
Yes.
law does not require, I mean, if I'm just for the sake of completeness, where the law does not require registration of a document.
Fine. For the time being, we are with you.
My lord.
Law exempts you.
Yes, my lord.
Show us some facts.
My lord, once the law does not require the registration of a document, then for the High Court to say that I ought to have registered a document.
Not dispense with evidence.
My lord,
Evidence must be there.
yes, my lord. So
Show some.
I set up the case of oral exchange, my lord, and I also say that the timeline shows that the deed is executed, my lord, for the commercial property, and 25 days later I come into possession, my lord. And from 93 onwards, I show my possession. It's only in 2008 that they come forward, my lord, to say that I was a licensee at the time of the wedding of my daughter, and therefore my license was only for a limited period. But 51
Okay.
in 21, your lordships issued notice on this very question, my lord, on section 118 as it's applicable to Punjab. But all I'll submit is on the limited question of law, your lordships may consider issuing notice. Otherwise, my lord, it's also a case where mandatory injunction has been sought without any relief of possession. And my lord, far beyond limitation. And secondly, my lord, I'll just make one more submission before your lordships. The trial court, my lord, looks at the evidence of the expert witness on the question of thumb impressions, and then, my lord, disregards it to examine the thumb impressions itself. My lord, I'll submit that there, my lord, the trial court could not have substituted its own opinion for the opinion of the expert.
Okay.
I'm obliged.
Thank you.
I'm obliged.
May I please?
Would your lordships consider issuing limited notice on the question of mediation if parties could be sent? It's a family matter at the end of the day. I'm obliged.
Lordship's last order had indicated
Lord,
that.
before my learned friend begins,
No,
I,
just drawing the last order.
no, just a minute. My Lord, I have a request to make. I'm appearing on behalf of the respondent. I'm ready and willing to go ahead with the matter. However, since this matter concerns my giving you details about child sexual abuse, I'm only requesting that the matter would be in camera in as much as we can continue in the courtroom. This is my request. But my lord, the courtroom may be cleared of people who are not concerned with this case. That's my only request. That's my only request. My lord, I don't feel comfortable talking about child sexual abuse in the presence of strangers. You're supporting my application. Should be in camera.
In fact, my lord,
That's different.
Well, that's my limited request. I'm happy to go on with the matter. I'm prepared.
the last occasion my lordship had directed me, did you interact with the child? In fact, I hosted the child for the entire day in my home without the presence of the mother. She was with us, played with the whole day. I want to assist my lordship as a counsel for the child. I want to appeal to my lordship's conscience and leave it at.
Well, Lord, I'm sorry, but we need to take a decided call on this issue.
We are discussing something else. Before
I'm
we
sorry.
come to
I'm
your-
sorry, my lord. Excuse me.
Please ask me in camera.
Lordships had recorded. Wait.
Eighth of September 2020. Our order dated 8th of September 2025 reads thus. Good. We take notice of the fact that last year, this court to which one of us, K.V. Vishwanathan J., was a part of the bench, had the occasion to interact with the parties, including the minor girl.
On 1/10/24.
Yes, please.
This for you.
The record reveals that the interaction had taken place on 1st of October 2024. Almost a period of 1 year has elapsed. We are of the view that we should have one more round of interaction with the parties. We direct the parties to personally remain present on
If I may make a request, my lord.
To do what?
on 16th of October at 2 p.m. We shall talk to the parties in the committee room.
And counsel. That will take care of your prayer.
My lord, I'll be obliged. Obliged.
We request the parties to keep the minor girl also present on that day. Was okay? That's
Lordship, the father did not get to interact also with the child for more than a year. Lordship would just bear this in mind. 31st March.
Wait till 16th of October.
Very well, my lords.
Obliged.
I have a list of dates. May I just hand that over?
Yes.
Yes.
Judge, I'll just take a little while on the parties because the names are all rather similar. So the appellant whom I represent the name is Gloucester Limited, and it is a successful resolution applicant or SRA. So this is arising from IBC. Respondent number 1, Gloucester Cables Limited, is an associate company of respondent number 2. Respondent number 2, that is Fort Gloucester Industries Limited or FGIL in this list of dates, is the corporate debtor who has undergone a resolution. And respondent number 3 is the erstwhile resolution professional. So these are the parties. At one point of time, historically, it was the Bangur family who owned these various, and that's why you will find that this Gloucester is being used everywhere. I might just by way of introduction mention what the controversies, and then I'll read on with the rest of the list of dates. There is a very valuable trademark, Gloucester, in the context of in relation to electric cables, which now are being manufactured by us. We, the appellant, having being the successful resolution applicant in respect to the corporate debtor FGIL. So now we have it. The trademark obviously came along with, according to us, with the company when we bid for the resolution process. Now the whole thing went through, and the resolution process has been sustained all the way up to this court, and we are completely in harness, so there's no problem at all. An application was, however, made, and the application was to the effect that, look, this particular trademark, Gloucester, had actually moved out from the assets of the company, and it vested, and this was in a sister concern prior to the date of the moratorium, etc., kicking in. The NCLT was pleased to reject this claim. However, the NCLAT has reversed, which is why we're here before the court. So this is broadly the issue.
One clarification.
Yes,
You are Gloucester Limited.
I'm Gloucester Limited.
Before getting into this CIRP and being successful resolution applicant,
Yes,
what were you doing?
jute. I was in the business of manufacturing jute.
You have nothing to do with cables.
No, I at that point of time did.
Why?
Right. But this company did.
Correct.
Yeah.
So you are not in the business of cables.
Now I am, but not
You are
then.
taking over.
Yes, correct. Absolutely
Now,
right.
since you are taking over Port Gloucester Industries,
Fort Gloucester, correct.
which is an associate of Gloucester Cables Limited, you want that this name Gloucester, this trademark Gloucester, should come to you.
No, so it's common ground that the owner of the mark was the company which was the corporate debtor, which is R2 Fort Gloucester.
Correct.
Okay, that's an admitted position. The question is that so let's keep all this. If ordinarily the corporate debtor, which has undergone resolution process, I have bought in and I am now running the successful resolution applicant, all assets of that corporate debtor would vest in me. I mean, that's the usual process, correct? That's the whole idea of resolution process. Now, what is being suggested by the contesting party is that this asset, which historically it's admitted belonged to the corporate debtor, at some point moved out of the corporate debtor and vested in an associate company, which now makes a claim with regard to this valuable trademark. That's where we are.
Which is that company?
That is respondent number 1, Gloucester Cables Limited, is an associate company.
So according to Gloucester Cables, at one point of time,
Yes.
it was an associate company of R2.
Yeah, that's not in
but
dispute.
Later,
No, it's not in dispute.
it severed the relations.
No, it didn't sever, etc. But severance, they had a relationship. That relationship continued, and they had the advantage, according to them, of this particular trademark being assigned to them. So they say that now I'm the owner of this particular valuable trademark.
So even after taking over Port Gloucester Industries Limited,
Yeah,
and you being Gloucester Limited,
yeah.
you will not be able to carry on business in the name of Gloucester Cables Limited.
Yeah, I won't be able to use that trademark unless I succeed.
You are already Gloucester.
I am Gloucester.
Trying to
So we are talking about a
fact.
trademark in relation to registered trademark that will come.
That
It's
registered trademark is
class 9.
Gloucester Cables Limited, right? You have a name Gloucester.
Yes,
Mr. Devan.
yes.
Nobody is taking away that name.
Yeah.
You can still continue with the business of this respondent number 2 in the name of Gloucester Limited.
No, but I can't use the mark qua electric cables unless I am the owner of the trademark.
So
It's a very well established trademark. Sorry.
now you want what name? What type of name?
Sorry, Yasmin. I didn't hear that last one. I'll just explain it, Manoj.
You are Gloucester Limited.
It will become very clear, Manoj. I'll read 3 more paragraphs. I'll just indicate what it is. It's Gloucester, sorry.
You continue. Only thing is that case appears to be R1 Gloucester Cables, correct? Claims that the trademark Gloucester
Yes, is now with them.
is assigned to it.
Correct.
So notwithstanding the approval of the plant and you are coming in as the SRA,
Yeah,
you can't use Gloucester.
absolutely correct.
Now, this they ask in a section 60 subsection 5 application.
Yes, correct.
Is it in relation to insolvency post the approval or is it a title suit?
No, so they've got a separate title suit.
That's going on.
Yeah, well, yes, there's a separate title suit which they have.
Post approval in May, they filed this application.
Yeah.
What is there any argument on maintainability of this application here to decide this issue? Ordinarily, what will happen? You
Right.
take the approval, you're gone.
Yeah.
You have approved the plan, the new management has come in.
Yeah.
You are assumed that you are using the Gloucester in your cables.
Yes.
He says, I am the owner, I have this assignment.
Right.
He will file an infringement action if it is registered
So
or
that can
passing
be
of a-
decided.
How does the NCLT get jurisdiction post approval?
So what he did was he first in point of time moved the NCLT and essentially said that, look, I have given documentation to show that there is already an assignment in my favor and therefore this should not be part of the resolution plan.
When did he say that?
He said that prior to the execution of, prior to the approval of the resolution plan.
To that is-
Yeah, so I'm going to, Manoj, take, because there was collusion over here, which I'll have to explain that. There was collusion over here, and I'll just indicate to your lordships as to, 2-3 points. So for the first point which your lordship may note is that as far as the moratorium is concerned, which comes in under section 14(1)(b),
You will take
With-
about half an hour.
No, I'll take a little longer than that, my lord.
Rest
I
of
don't.
the matters in the second session.
Yeah,
Rest
I'm
of the
grateful.
matters in the second session.
I'm grateful. So, sorry. So, can I just state the main point and then I'll go through the list of dates, because it's a little involved. The first point, which I'm just for your lordship's consideration, is that the moratorium comes into effect on 9th of August 2018, and you can have no effect 9th of August 2018, and you can have no alienation of assets after the moratorium. That's my first point. My second point is that the only way the law recognizes an assignment of trademarks is through a registered agreement in terms of Section 45 of the Trademarks Act, and absent a registered agreement before 9th August 2018, the asset remained with the corporate debtor, that is Fort Gloucester. The third element which I will show you is, it appears to us at least that there is complete collusion over here between two associate entities in trying to take away a valuable asset, and that ought not to be countenanced. Now, my lords, may I just proceed with the list of dates?
Yes.
So, para 5, the appellant, which is Gloucester Limited or GL, has filed the present civil appeal against the impugned order dated 4th January 2025, passed by the National Company Law Appellate Tribunal. By way of the impugned order, GCL's limited appeal filed against the order dated 27th September 2019, passed by the National Company Law Tribunal, was allowed. The short dispute in the present proceedings relates to the ownership of the trademark Gloucester, which is a registered trademark under Class 9 in relation to electric cables and wires bearing registration number 690772. It is R1 GL's case that the said trademark was owned by R2, which is Fort Gloucester, and consequently, under the resolution plan approved by NCLT, Gloucester Limited acquired FGIL along with the said trademark. On the contrary, the respondent's case is that the said trademark stood assigned to GCL, an associate company of FGIL. This assignment took place by executing two agreements. One, a supplemental trademark agreement dated 15th July 2008, and two, a deed of assignment dated 20th September 2017.
Just one correction.
Yes, sorry.
Para 6. It is appellant's case perhaps.
Yes, I think so.
Para 6. Para 6.
Yes, Manoj, it is not R1.
Appellant's case, no?
Yes, my mistake.
Yeah. Yes.
The third line in para 6. On the contrary, the respondent's case is that the trademark stood assigned to GCL, an associate company of Fort Gloucester. This assignment took place by executing two agreements, a supplemental agreement of 15th July 2008 and a deed of assignment dated 20th September 2017. Therefore, the trademark is an asset of GCL and not FGIL. While NCLT rejected the case of GCL, the NCLAT on appeal has, without considering the relevant facts and documents, reversed the ruling of NCLT and held that the trademark Gloucester is an asset of GCL. Now, just the dates: 1819, 1950. FGIL was incorporated in 1890. Sometime in 1958.
One second.
Sorry.
Resolution.
Oh, sorry.
Yes.
Sorry, first I was on the first serial number. There are two dates, 1890 and 1950. So the company FGIL was incorporated in 1890. And sometime in 1958, FGIL set up a plant for manufacturing electrical and power cables and began selling the product under the brand name Gloucester. The term Gloucester originates from the place Fort Gloucester in Howrah, which is where FGIL's manufacturing plant is located. In 1995, FGIL, being the proprietor of the trademark Gloucester, got the same registered under registration number so-and-so under class 9 in relation to electric cables and wires under the Trademarks Act. In 1995, the promoters of FGIL, along with certain third parties, incorporated GCL for carrying on the business of manufacturing electrical wires and cables, being the same product manufactured by FGIL. On 2nd May 1995, FGIL and GCL entered into a technical collaboration agreement whereunder FGIL provided license to GCL to use its trademark Gloucester for a period of 8 years. On 10th September 2001, BIFR declared GCL as a Sikh industrial company under SICA. In terms of the order, the company promoters were directed under Section 22A of SICA not to dispose of any fixed or current assets without the consent of the secured creditor. So this was the BIFR order, which was a standard order. Now, let's agreements entered into between respondent number 1, GCL, and Fort Gloucester. Fort Gloucester, in 2003, Fort Gloucester suspended its cable manufacturing activities. On 29th July 2004, a license agreement was executed by FGIL in favor of GCL, granting the latter an exclusive non-transferable license to GCL to use the trademark Gloucester for a period of 33 years, extendable to 99 years, for a one-time consideration of rupees 3 crores and an annual royalty of rupees 2 lakhs. On 10th November 2006, a loan agreement was executed by GCL in favor of FGIL, granting a loan of rupees 10 crores to FGIL. This loan was secured by a first and exclusive charge over the trademark Gloucester. On 31st January 2008, pursuant to the loan agreement, a memorandum of hypothecation was executed by FGIL, creating a charge over the trademark Gloucester in favor of GCL. On 15 July 2008, it is the case of GCL that a supplemental trademark agreement was executed between GCL and FGIL, whereby FGIL assigned the trademark Gloucester to GCL for a consideration of rupees 10 lakhs, which seemingly had been paid to GCL by FGIL. We'll refer to clause 1. This is the supplemental agreement. This agreement records that the assignment shall become effective without any further act or deed after vacation of the order passed by BIFR, because BIFR had otherwise granted an injunction and a restraint order. Note, it is the appellant's case that this is a fabricated document manufactured after commencement of CIRP of Fort Gloucester with the intent to retain the trademark Gloucester. This is evident from A, this agreement is not reflected in any of the financial statements of FGIL. Even the financial statement of GCL as on 31st March 2009 does not reflect execution of this agreement nor payment of rupees 10 lakhs. Lenders of FGIL were never aware of this agreement was executed by FGIL. During the pendency of proceedings before BIFR, FGIL clearly represented that it continues to be the owner of the trademark Gloucester and that the trademark had only been licensed to GCL, and this is recorded in the BIFR order dated 2nd March 2010 and 16th March 2012, on the assumption that this agreement was in existence since 15 July 2008, and both the transfer did not, had the transfer taken place, the point being made in subclause E on page 3 is that had this transfer taken place, there was no occasion to pay the license fee because there was no question of the license at all.
So come back to the previous page.
Yes, previous page.
Back to entry 10.
Entry 10, yes, please.
Before your note.
Yes, yes.
Now read that again.
I'll place it. It's the case of GCL that a supplemental trademark agreement was FGIL, whereby FGIL assigned the trademark Gloucester to GCL for consideration of rupees 10 lakhs, which seemingly has been paid to GCL by FGIL.
Now,
Yes, sorry.
kindly read the next three lines.
This agreement records that the agreement shall become effective without any further act or deed after vacation of the order passed by BIFR.
What has the 22A order got to do? Because that order is to restrain alienation of GCL's assets.
Yes,
This is alienation of other way around. FCIL is giving into GCL.
22A was against FGIL.
You see, 22A,
No, it declares-
the old Sika 22A.
yes.
Yes, it is for.
Oh gosh, well, there's a mistake we made.
It's an error perhaps in.
Yeah, there's an error. There's an error.
It should be, it's for Gloucester. See,
It's FGIL.
it's a.
Well, that's a mistake at serial number 5.
10.
No, in Sika. It was
The Sika order,
Sika order is right. Sika order would have said
no, it's BIFR declared FGIL.
for FGIL.
Yes, it's our mistake. I'm sorry.
But now it makes sense.
Yes, I'm so sorry, Manoj. I apologize. Manoj, I was on small clause E on page 3.
Yes.
On the assumption that this agreement was in existence since 15 July 2008, and both GCL and FGIL proceeded on the basis that the agreement came into effect on 1st December 2016. That's the date when the BIFR order was vacated. There was no occasion for GCL to pay a license fee of rupees 2 lakhs to FGIL in the financial year 17 and 18. So the fact that they paid the license fee is an indicator as to who the licensor was, even in 2017 and 2018.
It was closed in FGIL balance.
Even otherwise, the alleged assignment under the supplemental agreement is ex facie undervalued, as the trademark Gloucester had been hypothecated by FGIL for a loan of INR 10 crores. To overcome the above objections, GCL, by way of an application for additional documents filed before this honorable court, has now sought to introduce evidence of the following documents, which, my lords, we are resisting, but I will read this in any case. A board resolution dated 30th April 2018, passed by FGIL for executing the supplemental trademark agreement with GCL. Emails exchanged between the council, then representing GCL, and one R.C. Kalani from Jaishree Chemicals. It is the case of GCL that the draft of the supplemental agreement was exchanged between GCL and FGIL during the contemporaneous period. Bank account statement of GCL reflecting payment of INR 10 lakhs in favor of FGIL on 16th July 2008. GL objects to the production of these documents at this stage of the proceedings for the following reasons, and a reply to the same has been filed, though no notice has been issued on their application for additional documents. The only reason pleaded in the application for production of the documents at this stage is that GL has made out a fresh case on fraud. As elaborated in the reply to IA 93134, each of the arguments raised by Gloucester Limited, that's myself, in the present appeal have been specifically pleaded before NCLT and the NCLAT, and B, none of the conditions set out in Order 47, Rule 27 of the CPC are satisfied in the present case for the reason that GCL had ample opportunity to produce the documents before NCLT and NCLAT. Sufficient reasons have not been provided by GCL warranting admission of the documents. GCL is now producing these documents only to fill a lacuna in its case, which is not permissible. GCL has nowhere pleaded that the documents could not have been produced by it before NCLT and NCLAT, in spite of exercising due diligence. In the above background, the very genuineness of these documents is questionable. Now, Sika comes to be repealed on 1st December 2016. Now, on 20th September 2017, it's the case of GCL that a deed of assignment was executed between GCL and FGIL, recording as follows. In terms of the supplemental agreement, the trademark Gloucester stood assigned to GCL with effect from 28th May 2017. GCL has approached FGIL to execute the assignment deed to enable recording of the assignment before the trademark registry. As and when the assignment is recorded with the trademark registry and the name of GCL is entered in the subsequent owner proprietor of the trademark, the license agreement shall stand terminated. This agreement was manufactured fraudulently, that's my case, after commencement of CIRP by the promoters of FGIL with the intent to retain the trademark Gloucester through its related party, GCL.
Just a minute.
Yes, I'm sorry.
Brother also has this doubt.
Correct.
15/7/2008 supplement agreement. We'll keep aside your argument on fabrication.
Yeah, keep that aside. Keep that
Now,
aside.
for 15/7/2008 is the supplement agreement which is to be effective after the VAFR order is vacated.
Correct.
The order itself is vacated later.
Of 1/12/2016.
And now you have you have shown us this agreement now.
Yes.
That is
Serial number 12.
serial number 12.
Yeah.
Deed of assignment,
Yes.
recording that it will be effective from some date,
Yeah.
2015 date, I think. Anyway, any of these are registered.
So now that's the most important question. So that's one of the very interesting stories. So Manoj, I don't want to, like a movie script, I don't want to reveal what happened. So anyway, since your Lordship has asked me this question, let me just tell you. What happened was that without the IRP, or the RP knowing about it, the same lawyer representing both sides got the document registered subsequent to commencement of the CIRP process. So that's going to be my point, that registration is mandatory. It never happened prior to the commencement of CIRP. And what they did was they withheld all these documents. They withheld it not only because these huge valuable documents were not disclosed to the financial creditors, so nobody in the COC knew about it. And just at the 11th hour, when the matter is going up before the NCLT for the purposes of approval of the plan, etc., at that time, these documents are produced by the former promoters to say that, oh, all this is assigned, etc. Anyway, I will place that before you also. But that comes out in this list of dates. So to answer your question, there was no registration at the point of time until after CIRP commenced, which is according to us, if we are right, fatal insofar as their claims are concerned, because you have to have a registration. The moment the moratorium kicks in, there's no question of registration. So that's the other dimension to the matter. And the stamp duty is also paid later, 2018. So we'll just come to that. So now let's just go to the top of page 5. Top of page 5, if your lordships would. So these are short comments on the 20th September 2017 assignment deed. The agreement is not reflected in any of the financial statements of FGIL. That's important. Lenders of FGIL were never aware of this agreement was executed by FGIL, and the additional stamp duty on the assignment deed was paid on 24th August 2018, that is during CIRP of FGIL and a year after execution of the alleged agreement.
With private funds, not the corporate debtors funds. Whose
It
funds?
wouldn't be the corporate debtors fund, but I'll just check up, Your Lordship. I'll just check this up. Whose fund?
RP would have been.
Yeah, otherwise he would have known. Yeah, but he says that he doesn't know. He doesn't know. Now, please see commencement, my lords, of CIRP against FGIL.
Probably the assignee would have paid it.
Yeah, that's possible. Yes. Commencement of my lords, I'm on section C at the instance of one of its employees. So on 9th August 2018, serial number 13, a petition under section 9 of IBC filed against FGIL by one of its employees was admitted by NCLT, thereby commencing CIRP against FGIL. On 25th August 2018, an application was submitted by GCL through its attorney, depenning and depenning to the trademarks registry for registration of the assignment deed to have GCL recorded as the proprietor of the trademark cluster. Your Lordship, that was your question, correct? So this is an important date, 25th August 2018. Now please see 4th September 2018. Depenning, that is the firm which had filed the application before the trademark registry on behalf of GCL, issued a letter on behalf of FGIL stating the latter's no objection to register the assignment of the trademark in favor of GCL. See, it has now commenced, my lords.
25(8) is admitted.
Yeah, and 9th August 2018, CIRP has commenced.
No, commenced on 25(8). No, when was it admitted?
No, 9th August.
9th August.
9th August, my lords, sorry, it's admitted by NCLT, thereby commencing CIRP. Your lordships have that? Correct? Then you make on 25th August, there is an application submitted by GCL through its attorney to the trademark registry for registration. Correct? That is depenning. Now see what happens on 4th September. I'm just reading it. Depenning, that is the firm which had filed the application before the trademark registry on behalf of GCL, issued a letter on behalf of FGIL stating latter's no objection to register the assignment of the trademark in favor of GCL. Now this is, according to us, collusive conduct. The attorney who had given the NOC on behalf of FGIL was also representing GCL, and the RP had not authorized the attorney to provide any NOC, nor had knowledge that such NOC had been provided on behalf of FGIL. And this is pleaded by the resolution professional at page 11 of his counter affidavit. This is very serious, my lords, very serious. Now, on 17 September 2018, the assignment of the trademark Gloucester was recorded in the name of GCL by the registrar of trademarks. The registration of the assignment was barred under section 14(1)(b) of the IBC as it amounted to transfer of one of the assets of FGIL. So this is the other point, very, very important. Moratorium had kicked in by now. 22nd September 2018, the information memorandum published by the resolution professional in accordance with section 29, the information memorandum included a balance sheet filed for the financial years 2017 to 2018 as of 31st March 2018, which revealed the following: that GCL paid a license fee of INR rupees 2 lakhs to FGIL during financial years 2017 to 2018. Your Lordship sees this license fee is being paid, which is completely inconsistent with any notion that you are the owner. An interest-free loan from GCL was secured by FGIL by hypothecation of the trademark Gloucester. So that's also revealed in the balance sheets. FGIL had not recognized value towards the trademark Gloucester in its books of account, as FGIL had borrowed money from GCL by way of exclusive charge over the trademark. Now our notes. The RP has specifically pleaded that the trademark Gloucester was included in the information memorandum as an asset in terms of section 29 of the IBC, read with regulation 36 of the CIRP regulations. The supplemental agreement and the assignment agreement were not disclosed in the information memorandum provided to all the resolution applicants. On the basis of the clear disclosures made in the balance sheet of FGIL, all stakeholders, including Gloucester Limited, proceeded on the basis that the trademark Gloucester was legally owned by FGIL. Though this fact has no bearing, the RP in its reply before this honorable court has pleaded that the erstwhile promoters of FGIL provided the aforesaid agreements to the RP on the 3rd or 4th of April 2019. Before the NCLAT, the RP had pleaded that the supplemental agreement and assignment deed were never provided to the RP until the resolution plans were put to vote before the COC, that is before 24th April 2019. Of course, I am not in the picture at this stage. On serial number 18, on 10th April 2019, there's a forensic audit report for FGIL was submitted by the forensic auditor appointed by the RP. As admitted by the RP, a copy of the supplemental agreement and the assignment deed were not placed before the auditor. A copy of the agreements were not provided to the resolution professional when the auditors were appointed. On 11th April 2019, the 5th meeting of the COC of FGIL was convened, wherein the forensic auditor stated that there was inadequate support for the KMP of FGIL, the key managerial persons. So there was inadequate support by the key managerial personnel of FGIL as sufficient documents were not being provided by them. On 19th April 2019, Gloucester Limited submitted its final resolution plan with the RP. Insofar as a supplemental agreement and the assignment agreement are concerned, the resolution plan provides for the following. The resolution applicant believes that the said agreements have been entered into by FGIL with its related party GCL with the intention of transferring the said trademark to GCL with a malafide intention, although the said transfer was barred by law under SICA and is also barred under the IBBI during moratorium period. The corporate debtor entered into these agreements during the intervening period between the admission under IBBI and repeal of SICA. The resolution applicant therefore believes that the trademark Gloucester has been assigned and or transferred to GCL is bad in law. The resolution applicant understands that this trademark is the lawful property of the corporate debtor and the said trademark shall remain the absolute property of the corporate debtor post its acquisition by the resolution applicant. During the process of due...
Your bid was how much? How much did you pay?
74 crores.
74 crores, Manoj, I understand. And then we had to invest to get the plant operational. We have invested a further 40 crores. But that's, of course, to get the whole thing up and running. During the process of due diligence carried out prior to the submission of the resolution plan, Gloucester Limited discovered that the registration of the trademark was fraudulently transferred by GCL in its favor on the basis of the aforesaid agreements. It is thus for this reason that the above recitals were included in Gloucester GL's resolution plan. GL's resolution plan was approved by COC under Section 34 with a majority of 73.21%. Pursuant to the approval of the resolution plan under Section 30, subsection 4 of IBC, on 1st May 2019, CA 584 of 2019 was filed by the RP before NCLT for approval. On 28th May 2019, during the pendency of the above referred application filed by the RP, an application under Section 60, subsection 5 of IBC was filed by GCL before NCLT, praying for a clarification that the trademark Gloucester is not included in the assets of FGIL. The application has been filed by GCL on the basis of an averment that by way of the supplemental agreement read with the assignment deed, the trademark Gloucester was assigned by FGIL to GCL with effect from 28th May 2017. GCL has further pleaded that subsequent to the above, GCL is registered as the subsequent proprietor of the trademark Gloucester with the trademark registry and hence enjoys exclusive statutory and proprietary rights to the trademark Gloucester. The application was filed without enclosing a copy of the above referred agreements. The said agreements were brought on record before NCLT only by way of GCL's rejoinder in response to the objections pleaded by Gloucester Limited. Though not stated in the application, GCL has the following trademarks registered in favor by the name of Gloucester. Registration number so-and-so, registered under class 9 of cables and wires and all kinds of all kinds, including class 9, registration ending 2764, dated 31st July 2025, registered under class 9 for switches, MCB, RCCB, and distribution boards, registration ending 2775, dated 17/6/2020.
So right now, you're not using this mark for cables.
We are using it. We are using it. Yes. And we've started now that the commercial, because the factory has been started, etc. The present dispute, however, is limited to the trademark Gloucester, which bears registration 0772 and had been registered in favor of FGIL since 1st January 1960. GCL has, however, tried to refer to the other trademarks referred to in Note 3 above to claim the right to exclusively use this trademark. In June 2019, separate replies were filed by the resolution professional COC and GL objecting to the application filed by GCL. By way of the application, the respective parties echoed that the supplemental agreement and the assignment agreement appear to have been manufactured with the intent to divest FGIL of the trademark Gloucester, which is a valuable asset of FGIL and is essential for resolution under IBC. The relevant financial statements of FGIL reflect that as the commencement of CIRP, the trademark Gloucester was an asset of FGIL. 27 September 2019, a common order was passed by NCLT allowing the application filed by the resolution professional under Section 36 of IBC and dismissing the application filed by GCL. GCL's application was rejected with the following findings. GCL cannot claim any right over the trademark on the basis of agreements executed between FGIL and GCL between 2001 to 2006, as the said agreements were executed in violation of the BIFR order. The agreements executed in violation of court orders are void. The assignment deed is a preferential and an undervalued transaction as it assigns a trademark valued at INR 10 crore in 2008 for INR rupees 10 lakhs. Filing of an application by the resolution professional under sections 43 of the 40 and to 46 of the IBC is a procedural requirement. Since GCL approached the NCLT on the strength of agreements executed 2 years prior to the commencement of CIRP, NCLT can examine such documents in terms of sections 43 to 46 of the IBC. On 7th November 2019, a limited appeal was filed by GCL before NCLAT.
Second.
Yes, I'm sorry. Whichever document you want to show. Okay.
But this assignment, which conflict registered, is on that date. The registration of the assignment, fourth part.
So this was not submitted and there was no cooperation. So and here is report from the application.
Report came on 10th April that agreements according to investigation from everyone for pages.
not a finding about lack of registration. Or,
Yes.
or because there was a registration in the middle of the CER. Otherwise, your case is 2008 supplement agreement and the 2017 assignment deal are all got up documents. And actually what has happened is only a 2019 post-admission registration.
Correct, correct,
At the behest of depending without the involvement of the RP.
correct, correct, absolutely.
Just to show consideration having, otherwise consideration if it is done now should come into the CD's account. So they showed a 2000, it's your case.
That's right.
10 lakhs was transferred and 2017 document was formalized, not registered. Registration happened only in 19. In the 18, in the meantime, license fees were also paid, you are saying.
Correct.
Yes,
For a period post assignment.
Correct.
yes, yes.
Despite the agreement, license will come to me. Despite the second agreement, will come to me.
Just keep double check this. Yep.
So in A, that's your registration. Yeah. I don't have the execution, but it's not. But
Seems.
No, the first one, yes.
And for the second for items which will be shown.
Different document. This is the main one. So 6. Oh,
These are all record because
No, I was just on serial number 26. There was a limited appeal which was filed by GCL before NCLAT, assailing rejection of its application by NCLT. GCL did not challenge the approval of the resolution plan by NCLT. During the pendency of the appeal before NCLAT, no interim order was granted in favor of GCL. Now, on 27th December 2019, an application under Order 39, Rule 1 and 2 of CPC in COS 43 of 2019 was preferred by GCL before the City Civil Court, Hyderabad, seeking an injunction against FGIL and GL from dealing with the trademark Gloucester. The said application was dismissed by the court on 27 December 2019, inter alia on the ground that the dispute qua the ownership of the trademark is the subject matter of proceedings before the NCLAT. An appeal was filed by GCL against the order dated 27 December 2019 before the High Court of Telangana, which was dismissed on 14th February of the appeal by the High Court of Telangana, was also dismissed by this Honorable Court on 22/7/2022. The civil suit filed by GCL is still pending before the Civil Court, Hyderabad. August 2020, pursuant to payment of INR 72 crores approximately to all stakeholders, the resolution plan of GL was implemented and management of FGIL was handed over to Gloucester Limited. Steps taken by Gloucester Limited taking over the management of FGIL. After taking over the management of FGIL, there's an investment of rupees 187 crores made by GL towards renovation and refurbishment of the factory to commence cable manufacturing. As of June 2023, Gloucester Limited resumed manufacturing of low voltage electric cables. As of October 2023, Gloucester Limited resumed manufacturing of medium voltage electric cables. Gloucester Limited has begun business-to-business sales of industrial cables and is in the process of beginning sales of control cables shortly. With the resumption of commercial production in operations in 2024, FGIL has generated revenue of rupees 92.61 crores. On 25th January 2024 is the impugned order setting aside the NCLT order on the following grounds. An agreement executed in violation of an injunction order is not void ab initio and remains valid because the parties to the transaction subject to the directions passed by a competent court. So this was one finding against us. The supplemental agreement was contingent upon vacation of the BIFR dated 10th of September 2001. Hence, with the repeal of SICA on 1st December 2016, GCL became the assignee of the trademark. The registration of the assignment is not mandatory. Here, because I believe this is an error in law, is not mandatory, and GCL became the owner of the trademark in terms of the supplemental agreement. D, the forensic audit conducted by the resolution professional did not report any transaction to be undervalued or preferential. Hence, the assignment deed cannot be held to be undervalued, and no action could be taken by NCLT under Section 43 and 45 of IBC without an application by the RP. Now, can I just pause here for a moment? As far as D is concerned, what the RP has said is that these agreements, they were not available with him at all. There was no cooperation by the original owners and the promoters and the directors, the key persons in management. And he received this just a few after the forensic audit had commenced and just before the forensic audit was submitted. So there was no occasion for the forensic auditor to look into any of this because they were not made available to the RP. That's in the context. So this really, in our respectful submission, is taking advantage of suppression. But anyway, serial number 30, the present appeal allowing so-and-so, which is what we have filed. The appeal has been preferred on the following grounds: that NCLAT had failed to appreciate that the agreement basis on which NGCL was claiming ownership of the trademark Gloucester is a document which was manufactured only to ensure that the trademark is retained by the erstwhile promoters of FGIL through their associate company GCL, that the supplemental trademark agreement was executed in violation of an injunction of BIFR, and the trademark Gloucester during CIRP of FGIL was unlawful in view of Section 14(1)(b) of the IBC. Now, Manoj, may I just take you to a few of the documents? Yeah. So, Manoj, sorry, the first, if your lordship is just sees the BIFR order, just a couple of paragraphs. Page 100.
Starts at 93.
Starts at 92, 11 at 100.
What do you want to show?
At 100, at 100.
Manoj, would your lordship go to Annexure A2?
Yes.
Volume 1, page 93. Summary of record of proceedings held on 9th September 2001. 10 September 2001, page 93 at the top. Yes, ma'am.
Better.
Please go to page 100, clause 8. The company/promoters were directed under Section 22A of the Act not to dispose of any fixed or current assets of the company without the consent of the secured creditor and the Board of Industrial
Financial reconstruction.
Finance and Reconstruction. In case the company was running, the current assets could be drawn down to the extent required for day-to-day operations, proper accounts of which would have to be maintained. Clause 8. So this is the restraint from any alienation of fixed or current assets. And this, as your lordships have seen, comes to be issued on 10/9/2001. Now please go to page 163. This is Annexure A7.
Filed by GC.
So this is very dependency.
Yes.
Yeah, what is that?
Right, we will get to know also that.
This registration, which the LFG is talking about, that 45 of the trademarks is not required. It's mandatory.
So where's the main trademark?
This is the first one.
Supplement.
The name of supplement. That's in 2017.
Does it refer to any parent agreement? Yeah.
Yes, yes.
This one.
It refers to the license agreement.
So that's the main agreement.
Which was terminated by public supplement.
Hmm?
Which was terminated in 2017 by public supplement.
Yes.
I have further supplement.
Deed of assignment. There's actually no requirement of deed of assignment if they say.
Yeah, that.
But it's not just like 187.
Eight rows.
For 10 crores.
What is this now? BI for only.
This is
This in 2020, FGI had represented that it continues to own the trademark and what it has given is only license. So they were conceding the supplemental agreement from the lenders
And the BI.
and the parents.
Yes, section 22A of secret.
Yeah.
Where's the settlement? It's like this.
This ask them to give it.
106A3. DC myself.
Yes.
Today, there is no challenge to the approved plan.
There is
No, that's attained finality.
Final. The plan must have dealt with the trademark. What does it say about the trademark? Just see it in lunch.
Yes.
And suit is pending.
Yes.
Yes.
What is the situation if the only claim of a party is a certain asset claimed to be the asset of the corporate debtor is really not the asset of the corporate debtor, it is my asset in view of these documents. Has to be heard in the suit.
Yes, it could be.
And
Certainly.
you are already using it.
You are using,
Today also you
they have not
Yes.
got an injunction.
Yeah.
Now, your point that the agreement is fabricated, it was never assigned in accordance with law,
Yeah.
is a matter for the suit because to go into fabrication will be difficult in a 65.
All right, fair enough.
But the point about violation of the court order, of the AFR order, violation of the other point about registration,
Yes, registration.
all this can also be left to the suit.
Okay, I'll come back to your lordship. It may be possible. Why not?
All that can be left to the suit. Think about it, because there's a challenge.
But Manoj, that's on the understanding that these observations will obviously be effaced. No, just a minute.
Based on law. I mean,
Sorry.
no, we are not concluding.
No, I understand. But Manoj, if we are to consider going to the suit, then everything will be decided in the suit, including all defenses, etc. This NCLAT order ought to be. That's my submission.
We'll hear them, hear you.
Yes, of course, of course. But we'll.
Not occurred because suit was mentioned.
Yes, discuss with you. Yeah, either remanded or renewed. Huh?
The registration today is in their favor. If the suit continues, the registration today reflecting in their
Rectification.
Because my problem is that because of this clandestine and illegal registration which has taken place, you see, the earlier round in the suit ladder, I succeeded in resisting it because they had them come over here and filed it in the first instance. But today it becomes incumbent on me to endeavor to persuade your lordships that this registration itself could not have been done after the commencement of CIRP. It couldn't have been done.
See, what, in a CRP, all that happens is, one set of management goes, the other set of management comes.
Yes, but there can't be an alienation.
Assets, etc. continue.
Yes.
One party gets up and says, new management says it's my asset when it is my asset. He has filed a suit. As long as there is no bar for that suit in law to decide whether this 2008 was predated, whether 14(1)B was violated is also a defense you can set up. It is not that a civil court can't examine.
No, it can examine. Supposing we were not in CIRP and all of this had happened. Supposing we were not in the IBC ladder.
Only a new management has come and you say that I have now paid 72 crores primarily for this mark.
Yes, yes.
Without the mark, nobody would have paid. It's your case.
That's right.